was a good day. It took a long time for us to finally get to this point. We now have an order requiring them to produce documents that we've been requesting since January of basically 3 days after Coach was fired. The judge has also asked that USF provide revised privilege law with regard to these 800 documents that they're refusing to provide to us because those are documents under seal. Basically, here's what's been going back and forth, and I don't understand why if USF has nothing to hide, why they were fighting so hard to prevent us from getting these documents so that the truth gets out. It's as simple as that. We're wanting the documents. They're trying to keep the documents from us. There's two different legal battles going on as far as USF is concerned. The first is it's our position that the documents that the judge has under seal are public records, and they're required to produce them to us. And they were required to produce them to us back in January when we first asked for them. We asked for all the documents that had emails, texts, anything that had to do with anyone that participated in this issue, the investigation, the termination, the whole bit. They're trying to fight this battle under the rules of a private corporation, but they're not a private corporation, they're a public entity. And when you're a public entity, different rules apply to you. Public records rules apply to you. And we keep coming back on issues of these documents being public records, and they keep arguing that there's privileges that apply to these records because they're making an argument based upon the situation as if they were a private corporation. Well, they're not. They're a public entity. And this isn't the way a public entity should be behaving, because the law says that this is not what a public entity should be doing. There's rules regarding public records that apply to universities. They don't apply to private corporations, and that's really that's the back and forth that's going on. Is this an issue where privileges apply that private corporations can avail themselves of, or is this an issue where the public records laws and the privileges that apply to public entities applies? And I think what you heard in there, the judge correctly stated the law, that there basically is no attorney-client privilege that exists for a public entity. It made for a private entity, but not for a public entity. And that's what we're dealing with. So I think this is another step in getting records, this continual fight to get this background information. And the reason all this is really so important is because it is not fathomable that we've got a for-cause termination in this particular case with the testimony that exists from independent sources, in this case, that Coach Leavitt acted appropriately, and I think that the records that we're seeking are gonna back up the fact that there's probably other reasons and decisions behind this termination.